A railroad challenges 50 years of precedent on causation, but finds it's a lost cause in CSX Transportation versus McBride. Robert McBride worked for a railroad, CSX Transportation. The railroad assigned McBride to a train that had a hand-operated brake. McBride objected because the route and engine setup meant he'd constantly need to use the handbrake. The railroad insisted. McBride permanently injured his hand. McBride sued the railroad under the Federal Employers Liability Act, a federal law that allowed the employees of railroads to sue their employers for negligence that causes injuries sustained on the job. At trial, the court followed the Seventh Circuit's pattern jury instructions for cases under the Act. Under the instructions, the railroad could be liable if it contributed to or caused McBride's injuries, no matter how small a part the railroad played in bringing about the injuries. Over the railroad's objection, the court didn't include a proximate cause instruction. The railroad had suggested at least 2 different proximate cause definitions during litigation. The jury found for McBride but reduced the amount the railroad was required to pay because of McBride's own negligence. The railroad appealed, arguing the jury should have received a proximate cause instruction. The Seventh Circuit affirmed. The Supreme Court granted cert.